Tom Zone, Chief Superior Judge, and in terms of H534, the act relating to retail theft, the view of the court is that this is a policy decision as to how to structure this type of charge. As far as the impact on the court, it is basically, it's going to still be one trial where the state would have to establish the several acts, more than one retail theft. And so I don't see a significant impact on the trials. It's more evidence, but that's certainly something we can accommodate as opposed to having two trials. Also, there's a provision here for sentencing alternatives, which would add community restitution back in, also known as work crew, and we absolutely support that. We think work crew is a valuable tool in the toolbox, to use that phrase, for us to have. It helps with not only addressing individual cases, but in the grand scheme of things, it helps with the backlog, and there are several statutes that require work crew as a sentence. And so those cases are difficult to resolve if you have to have work crew as a sentence and you don't have it.
Just a quick question for you, Judge. This also might be a question for Mr. Fitzpatrick, but page 2, line 3, within a single county, is that sort of modifier? Does that exist for any other statute or criminal charge? Because I haven't seen that before.
No, I think the reason that you would have that here is because if you had two separate counties, who would be in charge? Let's say you had a crime where there's the one retail theft takes place in Windham County and the other one takes place in Windsor. Windsor says, well, I want to charge it in my county. Windham says, I want to charge it in my county. Who wins, if you will? Mm-hmm. And so this just says it's restricted to one county. That way we're assured of having one state's attorney in charge of the case and deciding how the matters will be charged.
Does the challenge come with the restitution piece, or because I feel like, I would imagine that the second act that brings it up to this level, if it's in a second county, the charge would take place in that county and the case would proceed there.
If that's something that you would like as the policy, you would have to change the statute to make it very clear. Otherwise, unless it says a single county, it would be unclear as to which counties gets to make the decision, which prosecutor. If they have conflicting views as to how to go forward, who wins?
Okay. I guess out of curiosity then, how does it get resolved in other cases where, if it's operating without an owner's consent and it starts in one county, ends in another, but also involves disorderly conduct or a burglary somewhere along the way, and how does that get worked out?
The venue for the charges takes place in the county where the acts occurred. Could you have the OOC as the continuing offense go theoretically in both counties? You could, but my experience is that that's worked out by the prosecutors. They decide who's going to take the cases, and usually it would go with the county where sometimes the majority of acts took place to say, okay, you address this. This would be different.
Thank you.
Thank you. Any other questions for Judge? Judge, well, that's the clock.
We'll make it
quick, so you got 3 minutes.
Thank you very much. Have a good day.
You too. Eric? This is a little 3-page bill.
Yep.
There's a lot in it, I guess. Simple little bit.
Good morning, everyone. Eric Fitzpatrick with the Office of Legislative Counsel, here to walk the committee through H534 as it passed the House. This is an act relating to retail theft. You may have a document that I sent Ben earlier this morning that is a map that shows you that a number of states have passed what's often referred to as organized retail theft or aggregate retail theft over the course of the past couple of years. That's what you're looking at in front of you now, a version of that approach, and just to give you a minute or two of background on, and as you heard from the judge, there's actually 2 different parts of the story. So there's the piece involving organized retail theft or aggregate retail theft, and there's a second piece involving work group. So I'm just talking for the moment about the first part, the retail theft piece. And that involves the essentially the distinction between the felony and misdemeanor retail theft charges under current law in Vermont. And we're talking about retail theft that's often referred to as shoplifting. So it's taking merchandise from a merchant's establishment. So often, as I said, colloquially referred to as shoplifting. Under current law, with respect to retail theft, as well as with respect to a lot of other property crimes, the distinction between whether the crime is a felony or a misdemeanor depends upon the value of the property that was stolen, or the value of the property that was subject to larceny, for example, or the value that was subject to a fraud crime. And that threshold in Vermont is $900. So that means that with respect to a lot of property crimes, if the amount of property that was stolen or that was defrauded was $900 or less, then it is a misdemeanor. It's charged as a misdemeanor. But if it's in excess of $900, right, more than $900, then it becomes a felony. So that's the state of the law. You may even recall there was a summer study committee many years ago, because people often ask, well, $900, that's sort of a funny number. Where did that come from? The summer study committee was trying to decide, they were trying to up that number from what it had been for many years before that. And I guess that they were evenly divided between 750 and 1,000. So they settled on 900 as a compromise. And that's why that number is what it is.
Representative at the time, she was representative, chair of the Judiciary Committee, Representative Flory at the time.
Yep, exactly.
Senator Flory. We chose the 900, and since that was so long ago, maybe it's time to up the 900.
Yeah, it was quite a while ago. That may well be. Yeah,
Well,
policy
I can't
choice.
remember how long ago it was. Representative Flory was chair of Senate House Committee.
That's right. That's right.
So, she served as a senator for 2 or 3 terms, then retired. And so I don't know how long ago it was.
More than 10, I'm sure.
Yeah, so it may be time to look at what is the
Right.
aggregate value.
So that's the current threshold, the dividing line between the felony and misdemeanor crime. So what the proposal you see in front of you, we'll look at the language in a moment, but just the big picture is to say that, like, for example, if someone were to shoplift, say, $500 worth of merchandise, because of the $900 threshold, that would be a misdemeanor crime. So what the proposal you see in front of you is to permit aggregation under certain circumstances. By aggregation, that means, well, if the same person, depending on the circumstances, shoplifts, say, $500 in one instance and $500 worth of merchandise in another instance, it permits the aggregation, the adding together of the 500 and the 500 to come up with 1,000. That may then be charged as felony. So that's the big picture.
14-day period?
Pardon me, sorry?
Within a 14-day period.
Yes, exactly. Yeah.
Quick question. Do you recall how they landed on 14 days rather than 15 days or
Yes.
13 days?
Yes, absolutely. So as you see from the map that I passed out, these sorts of statutes are in existence in quite a few states. For this particular statute, I use Florida's as a model. So the one that you're looking at there I was looking most closely. I looked at a bunch of states. That one is tracked most closely in Florida. But that time that you're talking about, the states that pass this sort of law, usually, there's like one example in Wisconsin, but for the most part, they set a period of time and say the multiple thefts have to take place within X number of days or X number of months. For example, Washington has 6 months. Minnesota has 180 days. New Mexico has 90 days. North Carolina, Virginia both have 90 days. Florida has 48 hours. So the 14 days was sort of in between that range. It didn't want to be as long as 180 days, 6 months, didn't want to be quite as short as 48 hours. So that's where the 14 days came from. Sort of it's not quite in the middle because it trends more toward the shorter length of time than the longer ones, but it was an attempt to think about what other states are doing and look for one that was a little shorter, but not quite as short as 48 hours.
Thank you.
Yeah.
But it's designed to get at organized retail crime. But
Well, the particular piece that passed the House does deal with organized retail crime in the sense that it's more than one offense committed by, and if you look at the language, it's over on page 2. Person who commits more than one retail offense, so it's more than one of the substantive violations, which is back on page 1, which is depriving a merchant of lawful possession of merchandise, that's essentially shoplifting. They commit one or more of those offenses in one or more locations. So it could be at the same store, but doesn't necessarily have to be. It could be more than one place within that 14-day period. So there is another piece that you may be thinking of, Senator Sears, the sort of organized retail theft that this committee has looked at before a couple of years ago, also, that often involves more of a conspiracy type situation. In other words, more than one person working together. But that is not in this bill. That's not what
We're
passed
not
out.
really dealing with organized retail theft.
That's more aggregate retail.
Yeah, we're dealing with aggregate, and I think it's like, it's ignoring what's going on in other states, which entails careful planning, deliberate targeting of retailers, and high-level coordination among perpetrators. So we're not dealing with that here. We're just dealing with, not my estimation, this is not what if you wanted to get at those groups that target a store, for example, and come in and steal thousands of dollars worth of materials, we're not dealing with that.
Yeah, I think that's another option that the committee certainly has. It's a policy choice for you. But that's also an angle that I think you may recall was in a different bill the Senate looked at a couple years ago, and it's actually in the House bill was introduced, but it's not in the version that passed the House. This, as you mentioned, Senator Seals, deals with more of an aggregate situation. So when can the amount of property stolen be aggregated? If it's when it's stolen, as I mentioned, in one or more locations within a 14-day period, and to follow up on your question to the judge, Senator Hashim, that within a single county language is unusual in that I don't think that it appears anywhere else, but it responded to exactly the situation that Judge Zone described. In the House Judiciary Committee, the state's attorneys were concerned that it would be unclear if, for example, the theft took place in more than one county, which state's attorney would have jurisdiction to prosecute the matter. And so that's why they asked for that clarifying language.
I mean, my initial thought is, rather than it being within a single county, I would recommend having it be where a majority of the value of items was taken. So, if you have $700 worth of items stolen in Windham County and then $400 worth of items stolen in Windsor County, I think it would make sense that it is handled in Windham County where the majority of the value was taken, because it's, I get that within Chittenden County, it is a retail and commercial hub, but there's also a lot of cross-county travel and places that aren't in Chittenden County. So,
well, you could have, Manchester is a retail hub. You could have somebody stealing stuff in Manchester from Rutland, who also goes into the Walmart in Rutland and steals stuff.
Yeah.
So which county are they gonna be aggregated?
I would say the majority, or where the majority of the value of the
What's the problem we're trying to get at? That's what I need to hear from witnesses. What's the problem we're trying to get at, and how's best to deal with it? For example, California has a law about organized retail theft, which involved acts in concert with one or more persons steal merchandise for one or more merchants' premises or online, with the intent to sell, exchange, or return the merchandise for value. Two or more persons to receive, purchase, or possess merchandise, all those things. And then it goes on and on and on, but it's organized retail theft. And I thought that's what the problem was. So anyway, that's this section here.
The only last piece I'd make is the penalty. You'll see that the penalty, if the aggregation applies, so in other words, if more than one of these retail thefts is aggregated, then pushes it into the felony category. So in other words, it would be, see line 4, page 2, $1,000 imprisonment, not more than 10 years. That's the same penalty that is in existing law. So if you look back at page 1, lines 19 and 20, that is the same penalty that you have currently for the felony. So felony would apply if you could aggregate 2 misdemeanor offenses.
So we have,
Lastly, there's a sunset. You see line 6. So it's a 3-year, essentially, see how it works for 3 years, and then sunsets 2027.
why would you do that?
That's all hinky.
Why would you do that? I don't understand. We never did that.
It's like saying we know we're going too far, but we're
gonna only go so far for 3 years. Senator Norris.
Yes, Eric, just bear with me on this. So for my clarification purposes only,
Yes.
everyone else probably has a total grasp on this. On page 1, section 2, A and B, those are already existing on the books.
Correct.
So it appears that the only thing we're trying to do is on page 2 is to compound more than one more than one retail theft within a 14-day period that exceeds $900 in value will become a felony now. Is that what we're trying to accomplish here?
Yep.
So
Total.
So that's nice, but I guess if the bad guy or the accused reads the law, they'll just wait till the 14 days goes by and then just come in and do whatever they do. I mean, on day 15 or 16. So I guess I'm a little concerned about the 14-day. It's kind of like open game. After 14 days, you go back and do it again. $8.99 on day 1 and then $8.99 on day 15. I mean, I don't know what's the point here.
But they
I'll leave
have
that
to
the
do
way
it
it
at the
is,
same
but you're
time.
right. If it's day 15, it doesn't apply.
$8.99 on day 15.
So I can go to Manchester, steal $8.99, then go to South Burlington and steal $8.99, and I'm still in a misdemeanor because I've gone to
Different counties.
2 different counties.
Exactly.
But if I'm dumb enough to do it in the same county, I'm now on a 10-year felony.
Senator Hashim had a question?
Yeah, it was more of a comment, I think, to something you had described earlier regarding multiple people. So I believe that we have on the books conspiracy, which is 2 or more persons planning an offense and they take a substantial step towards completing it. Is that something that would get to the concern of multiple people planning large-scale retail thefts?
No.
No.
Conspiracy only applies to several listed offenses, and retail theft is not one.
Thank you.
Thanks. I am remembering, I had a bill trying to do something similar a couple of years ago.
Yes.
And I'm remembering the testimony from the Defender General. And he said that he thought it was probably, I'm remembering his words, probably unconstitutional to aggregate crimes in the way that this is contemplating. The other concern he brought up was, he said that in this case, when it says that they commit more than one retail theft, wouldn't they have to be adjudicated and found guilty of committing the offense?
Each of them.
Right, but the 14-day window then would be crazy. Like, how could they possibly be tried, found guilty twice in 14 days?
No, I don't think you have to be tried and convicted of the first offense prior to being charged. I
Well,
think
it
they
says-
commit the 2 offenses, and they both of them, and I was speaking with Judge Zoni about this before testifying,
Yep.
that they would both have to be proven and convicted of each offense, all in
So you'd have
one
a single
trial.
trial
Exactly.
for 2 offenses.
Yeah.
Okay, so I'm just
2
trying,
instances, in a sense, of the same offense.
I'm just trying to walk through how that would work though. So somebody goes into Outdoor Gear Exchange, which is a big locus of retail theft in downtown Burlington. They steal $1,100 worth of stuff. So they would have to have been stopped. That merchandise would have had to have been listed. Then their police come
and they're issued a citation or they've got a date in court, and then it happens again. How do both of those arrests connect to each other? How does anybody know about the first one?
I'm gonna leave that to the witnesses to describe. I think
Okay.
that you're correct procedurally. Citation was issued for the first one. I think you probably meant that it was gonna be less than 900. You said 1,100, but you probably meant
Yeah,
less, right?
or either one.
Yeah, so, because you're talking about hypothetical aggregate situation.
Yeah, yeah.
So let's say it was 800. They give you a citation for that because it's misdemeanor, non-witness misdemeanor. So not arrested, and they do it again, they steal another 500 5 days later. So it's within the 14 days.
Right, but it's within the county.
Right,
So let's say now they're not in Burlington, they're in South Burlington at Coles, and they steal 750. How does the arresting officer in South Burlington know about the previous one? Would they check a database and they see that there's a pending citation and then they see that it's within the 14-day window? Is that?
Yeah.
Okay. I just find it hard to believe that this is gonna actually, in practice, and maybe it's the 14-day window, just seems hard to imagine that you're gonna catch somebody in the act within 2 weeks and the entities involved quickly enough realize that and then bring this statute to bear. So I don't know. But anyway, I know that Matt Valerio did have constitutionality questions about, but if they're being prosecuted at the same time for both, then maybe that's how you get around it, because what he was thinking of was that you were gonna be prosecuted sometime earlier in the year and then a good deal later in the year. So maybe it's the fact
I
that.
envision it as I think
A
Jeff
single-
Tony did as well. It's a
I
single
think the
thing.
Defender General's on our agenda for later today.
Perfect. Yeah, because that was, we tried a couple of years ago with this and procedurally we couldn't make it work.
Yes, I remember that.
So,
Yeah, so, anyway, we should probably hear from the witnesses, but I'm more interested in organized retail theft than I am in this 2-week
Mhm.
version. Yeah, we're gonna do it, and we should do 2 days or something like that, but it's more reasonable timeframe.
I was
We also should ban, if we're gonna do this, we should ban self-checkout.
Can we please?
That's where a lot of this stuff comes from. Is people using self-checkout, they check out one item and then they leave with 10. The poor person at Walmart is supposed to catch them.
Yeah, let's ban self-check.
I'm here for it.
Yeah, let's,
I used to hate that, but
Use it
now
all
it comes in
the
really handy.
it does come in handy.
Those of you who
I
like
have a moral
self-checkout,
objection. to
I am not
self-checkout.
I'm not gonna oppose that change here today.
I would support it if you'd
is
like
this
that
a
amendment.
labor-based?
But
offense?
I wonder about, what is it we're trying to get at? Is it organized retail theft, or is it the person who is shoplifting daily? And I would think a shorter than 2-week period would be more appropriate.
See, I was thinking a longer than 2-week
Huh?
period. I was thinking a longer than 2-week period,
Oh.
because if somebody's caught and processed by the police, it seems to me that the odds that they're gonna go do it the next day are not great, but the odds that they might do it that month would be better. I just don't think, it's a construct that I have a hard time seeing happening more than a couple of times in a year, maybe.
We have a miscellaneous corrections bill coming, by the way. It might be better to put the work crew in that bill.
The work crew.
Huh?
What work
Section
crew?
That's the second section.
Oh, I was like, what?
It's like on the
So on
chain
in
gang.
section 3.
Okay.
4.
I just must have missed. I thought we took a pretty heavy swing in another direction.
It was Cool Hand Luke territory.
Yeah.
Well, they're not in uniform.
Okay.
They don't have to wear stripes or malls on their legs. Iron.
We had.
Did it
It's a
really
failure
get
to
rid of the
communicate.
one?
My favorite
I think
one.
the OC got rid of it.
I think the Department of Corrections got rid of it, and this is to revive it, I think.
I don't know that I feel great about
The
that.
intent of
We
the
call that
General
the
Assembly,
housekeeper,
Department of Corrections,
proposal.
I believe. Anyway,
So, yes, you're right, Senator, so it's very simple, it just reinstitutes work crew as an option, a sentencing alternative, it adds it to the list. It had work crew before, it was, repealed, I'm not really sure why, you'd have to ask
When did
DOC
it go
about
away?
that. I'm not certain the exact date.
But like a year ago, 10 years?
No, it's been more than a year, it's been several years.
It's a tough one.
one state, Bellini retired, who was president of the VSEA, and who was running the work crew in Jacob County. They waited until he retired, I think that was when they did it.
I see.
Can't remember how they retired. But their argument was, and it was legitimate, that there were few on it, and many of them who were on it were being, were not participating and then being charged with not participating in the work group. So we need to, before you finish that, question, and we need to decide whether to put this here or deal with it in the miscellaneous corrections.
The work crew?
Yeah,
I would oppose the work crew. I wouldn't even put it.
well,
You want it out of
you
this.
can
bill.
oppose it, but I don't know that it has anything to do with this bill.
Yeah, I can agree on that.
Yes, I can agree on that
Senator
one.
Norris.
Yes, getting back to the retail theft rate.
Yes.
So, the reason for my confusion on this, Eric, is, let's just say somebody is charged with $750 theft.
Mhm.
And within this 14-day period or whatever else, they're charged with $300, which puts them at that felony level.
Right.
So they're charged.
Yep.
What if they're found innocent, the first $750? Does the $350 felony charge still exist as a felony, or?
No. No, they have to be, it has to do it in conjunction. They have to be, both charges will be brought in one proceeding. At least that's the way Judge Zoni described it to me. And, they both have to be proven. So if one of them was not proven, then no, you couldn't have a felony
So it
anymore.
reverts back to
The
another.
misdemeanor. Second.
Does the 14-day window come from Judge Zone trying to answer the question of what conjunction would mean?
No, the 14-day window is really just, as I was mentioning earlier, a number of states have these sorts of statutes. It's even in the last couple of years, I passed out a map. These are just states that passed in the last couple of years, and they use a different, there's a variety of times that they use it. Everything from as long as some states have 6 months, 180 days, more than one offense in that period of time. Others go 90 days, and it's as short as Florida is 48 hours. So I think it's a more of a policy discussion upstairs as to what's the right amount. We don't want it to be too short, but not too long either. And so that's where they landed on 14 days.
I don't mind trying to deal with organized retail theft. That's one trend. Continued shoplifting is another, and the way we would normally deal with it is first offense is, anything under 900, and, it's a misdemeanor, minor misdemeanor. Second offense continues to be a misdemeanor, and finally, third, a subsequent offense would be the felony level. So you would deal with it based upon that. That's how it's normally done in criminal law. This one tries to aggregate something, and Senator, you're absolutely correct. I think it's difficult. Senator Norris is correct. What if they get found not guilty of this, then blah, blah, blah. So, that's the way we would normally deal with if you wanted to make it more serious. Second, subsequent offense. The second item is, this is not organized retail theft, even though you're using some of the language. This has nothing to do, because organized retail theft is 2 or more persons. Correct?
I think the term has been used broadly in the statutes that I've looked at. But I think you're describing, yes, one of the other classic situations that was in the bill as introduced and in the Senate bill that you guys looked at a couple of years ago, which involved more than one person working together.
Yeah.
So, yeah, I think that's also another.
Senator Dowse.
I recognize that I may have missed Judge Zone, but it also, this sort of what's being described is potentially going on with these multiple different charges that might go this way or that way, creates a sort of logistical nightmare in the court system, which we already know is struggling to keep up with the cases coming to it. So I'm concerned that it creates sort of, I know we talked about this in another context, a different kind of sort of ping pong effect of like, is it a felony, is it a misdemeanor? I don't know, I gotta go track this down and see if that's happening. And it just seems overly complicated.
And especially in an environment where we're trying to clear the backlog.
Yes.
And we would be, well, I feel this way also about the car statute. It's theoretically, it's gonna add a bunch of people into the system for things that they're now not currently entering the system for. But this one, I really have a hard time seeing how somebody, even within a 14-day window, I can't imagine a 48-hour window. How could that ever wind up being the case if somebody has to be charged, cited? I mean, they would just basically have to leave the police station and go rob somebody again or steal something again, which maybe they're doing. But in other words, this has always struck me as a kind of wishful thing. Like, we wish there was a way to isolate the person who's doing multiple retail thefts and give them a higher penalty by aggregating. But especially if they're being charged with multiple offenses, and if they get cleared on one, this no longer applies.
It doesn't do anything about the person who steals $300
Right.
stuff,
Right.
which is also frustrating.
Yeah.
I think my additional concern as we talk about unintended consequences is that so what we know is knowing that you might get caught and being able to access or going through the system quickly is the biggest deterrent on crime and actually enshrined in our Constitution, that right to a quick and speedy trial. And creating this additional complication to me feels like it would actually have the exact opposite effect of bringing someone quickly to justice, but in that it would further burden the
I
courts.
think that we're having discussions that may be better for another witness than Eric, who has to remain neutral.
Fair.
Oh, I can remain neutral. I'm good at that.
Well,
That's
My
fair.
favorite part of the
I
job.
would like to consider that we go in a different direction and that we consider raising the $900, which hasn't been raised in whatever number of years. Number two, consider the number of offenses rather than aggregating. So if you got a first, second, third, fourth offense, then it becomes more serious because you're continuing to do the behavior, like we do with most crimes. And then having something regarding organized retail theft, which I thought was what we were trying to get at, which is the growing problem nationwide.
Well, definitely, over the last few years, retail theft, organized retail theft is one. The other one is the persistent perception that $900 is too high a bar. And so people, and I've never believed this, but people very seriously say that these folks are calculating as they go and they get up to 850.
You know, that's fine. We could do,
Yeah,
I think it's better to do first and second offense than.
I do too. Because frankly, I don't want to lower the 900 down to 100 to catch a bunch of people, because pretty soon you're where England was in the 18th century and you're executing people for stealing a chicken or something.
And then, can we agree to hold off on the work crew until we get to the miscellaneous corrections?
I prefer to eliminate the word.
Well,
We can have that conversation in miscellaneous.
Discussions on that now.
Exactly.
Alternative to incarceration.
some of us might like work crew.
And I'll play my.
In my retirement, I may wish to run work crew.
I don't know, my retirement plan might be prison in Norway, just saying. They're lovely. Better than most dorms and apartments in the United States.
But
Yes.
you seem disturbed.
Oh.
So, Eric, and the sunset is an interesting,
Yeah,
so.
that is unusual.
Well, I think, for example, it was in the waiting period, firearms waiting period last year. I think the idea was to see how it worked. For here, at least, it was embedded in the statute the way it was in the waiting period.
Well, wasn't it just the gun show?
Yes, exactly. Yeah, exactly.
But if we do this. Who knows who will be here July 1, 2027 to remember. I'm sure Eric will remind you here.
Right.
Senator Norris.
Yes, I want to try to release some of my frustrations here. I'm having a problem with the overall bill in itself, the way that it's written, the sunset, the 14 days, so on and so forth. I believe, and correct me if I'm wrong, the way that I'd like to see this go is you get a DUI 1, DUI 2, and a DUI 3 becomes a felony.
Right.
No time involved in whatever this. So if we stay with the same amount of money, whatever else, and we go upon conviction of first offense of retail theft, second offense of retail theft, and the third one that exceeds the $900, okay, then we could look at possibly a felony. But this just seems to be a nightmare with the database and keeping up with this. In Valcor, between issuing citations, six weeks
Has
down
to
the
be in the
road.
same
I don't think just, but I do think that if we look at a first and second, or even a third offense, but once it gets to once those offenses go past that amount of dollars, it becomes a felony, is all.
Well, and maybe I'm wrong, but I think the problem there would be, so the complaint has been that prosecutors won't prosecute, police won't be interested unless it exceeds $900. So this is a way of getting past the $900 with individual incidents that aren't 900. So if we're talking first offense, and the first offense is over $900, then it doesn't get to that problem where they believe that people are, that their big problem is people stealing under 900 multiple times. So in other words, the first offense, what they're saying, the critics, is that it would never be prosecuted because it doesn't exceed $900. You know what I'm saying?
Mm-hmm.
Well, maybe we should get prosecutors to do what they're supposed to do. I don't know, but I mean.
Well, and then there's a disagreement with respect to the chief. There's a disagreement about whether it's prosecutors don't want to do it if it's under 900, or whether it's police don't have the manpower if it's under 900. But people seem to agree that no one is interested in a retail theft of $200, even if you have the person there.
Depends on the county, which is nice though.
Yeah.
I think in Bennington County, you're more likely to have a charge or be diverted if
Yeah.
it's $200 than perhaps in Chittenden County.
Yeah,
So I would agree, I would think in most counties, if it's $50, nothing's gonna happen.
right.
So if the prosecutors, as you say, don't want to mess with the $300 retail theft, then if they're saying we're not going to charge this, and law enforcement goes and charges them, issues them a citation to appear in court for $300, knowing they're not going to charge this, how do we get past the $900 and if they're never going to charge for that original offense?
And that's the riddle. That's why we keep coming back around is either we drop 900 to 300 and we draw in a lot of these for first offenses and second offenses, or we try to aggregate them. All the schemes for aggregation have seemed to fall apart once we get talking about them. So I don't know. I would be interested in what Matt Valerio has to say about this, because I remember he was the one that really put the spike in.
I'd be interested in hearing from Rebecca Turner.
And the chief, if the chief has to.
I don't think,
law enforcement.
Matt has had some challenges because of short staff, so he's having Marshall or Rebecca come
Yeah.
for him. But which is fine, but if we first have Sean Burke, Chief of South Burlington Police Department. We're finished with Eric.
Yes.
Well, you've heard the discussion, Eric.
It's not over
I
yet.
don't think things are looking good for the
Fitzpatrick.
bill has passed the House.
Well, I never
I
take
think
it personally. I
you
know
may
it's
be
not the
right.
quality of the writing that you're disagreeing.
Good morning. Thank you for the opportunity to testify on H 534. Again, my name is Sean Burke, and I have the privilege of serving as the Chief of Police in South Burlington. South Burlington is a major retail hub which draws Vermonters from across the state to shop, work, and enjoy all the city has to offer. Our community has experienced a dramatic increase in the number of reported retail thefts in recent years. The brazen and frequent nature of retail theft has eroded the perception of public safety in our most vibrant centers. If you have my testimony, it shows a graph of reported retail theft incidents in South Burlington, 2018 through 2019, pretty static, around 300. A dip in 2020 to 257. In 2023, we were up to 492 reported incidents of retail theft in South Burlington alone. Despite our staffing challenges, we respond to each and every single report of retail theft. We may have to prioritize those calls depending on what else is going on, but they all get attended to. We do not have an online reporting situation like other municipalities employ. There are a manageable number of recidivists who are driving this data trend. Many of these people are justice involved, substance dependent, impoverished, and are open to help. Others are treatment resistant and are unwilling to change their criminal ways. There is no sense of accountability. The department has also seen an increasing number of cases where suspects are stealing very specific items which are traded for drugs. Drug traffickers then sell the stolen goods on the illicit market, essentially doubling or tripling their income, the income of their criminal enterprise, an actual organized retail theft scheme that is overlooked as petty property crime. Our department refers a majority of misdemeanor retail theft cases to our community justice center. This system aims to resolve the case through a restorative justice process, and we have seen great success with first-time offenders in this model. The recidivist population isn't interested in learning about the impact of their actions and encourage us, the police, to send their cases to court because there is little risk of consequence. In order for a criminal justice system to be effective in deterring crime, there needs to be at least two things: a probability that the offender will be caught and that a consequence will be imposed. The proposed changes in H 534 help address the prevailing retail theft crime trends seen today, establishing a felony standard for clear recidivism or those operating in an organized manner, enhances the likelihood of an actual consequence being imposed, a critical piece of an effective CJ system. There are true consequences of being convicted of a felony, long-lasting consequences. Absent new ideas about how to hold offenders accountable for these chronic misdemeanor offenses may leave the felony option as the best one. There have already been statements made about the effectiveness of tough on crime policies and the impact those policies have had on historically marginalized populations. This isn't tough on crime, it's procedural justice. All Vermonters deserve to feel safe in the places they live, work, or otherwise spend their leisure time. The reality facing Vermont is we have a substance use disorder crisis, we have a mental health crisis, and we have a housing crisis. All of this is playing out in the public sphere and is perceived to be a public safety problem. We need to get serious about addressing these challenges in order to restore order in our public spaces and better serve all Vermonters. Parallel to this, recidivists and those operating criminal enterprises need to be held accountable for their deliberate acts. With that, I'm open to any number of questions.
Well, I guess you've heard some of the debate within the committee, and I think there's some logistical problems with this House version. The first is within a single county, which I'm not sure what that difference makes it by. Many of these folks travel from one county to another. Just that borderline doesn't really make it, to me, any difference. Second is how we get at this. And as you point out, most people, the system resolves the cases, they go to return to justice, and we don't hear from them again. there's a few people that come back at us and come back at us and come back at us. And it's those who you're trying to address.
Yes,
I'm
certainly.
not sure that this 14-day period addresses that, or the getting above 900, so if they steal 250 today, 250 tomorrow, 250 the next day, they're still below 900.
Certainly. I think I would like to leave the venue question to Judge Zone, but I suspect it is really to ensure that the trial to prove each and every offense supporting the felony aggregation occurs in one court. But
I see.
he would be the absolute expert on that. I would not.
That makes sense.
In terms of the mechanics of knowing who has been charged with what in what period of time, the data is available, but the data is not always clean. And, there could be an arrest made in Burlington and the investigating officer may not get to actually completing all the data fields in our shared records management system within the 14 days. Just the way it goes. We do have really good visibility on what defendants have been charged with in criminal court through our access, our dispatcher's access to the court records in that regard. I don't know if this necessarily gets at the crux of the problem. What I see as the real critical piece here is that we have this group of recidivists out in the community committing retail theft after retail theft, which is now in concert once they're arraigned with a violation of conditions of release, with total disregard for the system. And it is cutting at the economic vitality of our major retail hubs in Chittenden County and across the state, and even where margins are even smaller and loss is even more great.
Some of the stores in the Bennington area put no trespass orders against certain individuals. I don't know if they do that in South Burlington. That seems to be one effective way to deal with the recidivists. Do you have any experience with that?
Certainly, that is a tactic that is also used, and I will say, retail theft is largely underreported. What drives our numbers are professional loss prevention staff at major major retailers, and they will watch their cameras and know, like, oh, there's Sean Burke, we've got him on a notice of trespass, let's call the police, and we intervene there. I think it does work in the smaller stores too, where you have a consistent person at the counter to know who's allowed in, who's not. But it really doesn't deter what we've seen in terms of the determination to commit these crimes, because as I illustrated, a large number of the folks committing these crimes are wrestling with opiate use disorder, and they need to steal certain goods as identified by their drug traffickers in order to obtain their drugs. So a common thing that is stolen right now are cordless power tools from big box hardware retailers. Thousands of dollars of these tools are being traded for very small amounts of drugs, and the determination is the offender's addiction. That's what's going to make them keep going back time and time again. And the notion that, are they going to think about in a very intentional way, was I arrested 14 days ago, 15 days ago? No, they know they need drugs today. In order to make that transaction, they have to steal a certain item.
Senator Dawes.
Yeah, so one of the things I think sometimes happens when we're looking at a crisis is we change all the things all at once. And one, that's sort of problematic just from a scientific standpoint. We have no idea what worked and what didn't. And two, often I think it causes the pendulum to swing really far in the other direction. And so I guess we just worked on S-195, which is meant to deal with recidivism and violations of conditions of release. Could that actually, and would stand up a system of oversight for people who have violated within the Department of Corrections? Could that be the change that actually stems some of this tide rather than changing all the things all at once?
So certainly, the federal system uses a very robust pretrial monitoring program. They actually get a report at arraignment that's similar to a sentencing report that our state court judges receive. It's going to cost a lot of money. I think we've all heard the administration's position on what's available or not available fiscally. And, in between are the rest of us trying to, keep our community safe and really reconcile or lead our merchants through their losses and whether or not they're gonna have to shutter their doors, and why aren't these offenders being held accountable. I feel we need a lot of investment in a sense of accountability early in the process, and that's pre-trial. Not necessarily facing a felony that might come your way at sentencing if the trial docket frees up. I don't know if that's the consequence that we need, but I feel as though that there is an urgency to do something for our business community.
I don't disagree that there is a need to do something. I just don't know that we need to do everything. And I think it's also going to cost money to incarcerate more people on felonies and to put more people through the court system. So I think it's about really being strategic and thoughtful about where we make that investment. And I'm inclined to agree with you that a sense of accountability pre-charge is a better investment than heavier charges, given what we previously talked about, how that doesn't actually deter crime. And so I have trepidation about sort of making all the changes when we've already sort of looked at a space where I think the investment might actually really work. And it does, to the extent possible, we have a different constitution, mirror some of the federal pretrial supports and services for groups of people that are identified to be likely to recidivate.
Well, I think I'll start with my first question with Eric was, what are we trying to get to here? What is the problem we're trying to solve? And it's obviously, for you, Chief, it's a repeat offender who's consistently doing retail theft. And I'm not sure the amount matters as much as the continued behavior. And one way to deal with it has been in many communities is no trespass orders, but that's hard to enforce at a big box store. Other, somebody's retailers use no trespass, and then they call the police when somebody tries to come in. I'm not supposed to be there, but it's the repeat offender, and I'm not sure aggregating and within a single county, and I understand that's a problem. And then we're trying to be proactive in dealing with organized retail theft, which I'm not sure how much we've seen yet in Vermont, but it'll be here if we haven't had it already. So I think those are two problems. I'm not sure the way this is drafted, it gets at either one of those problems.
And listening to your deliberations during the walkthrough, I was thinking the same, and knowing what I had written, I said, I don't know how helpful I'm going to be, but I do feel that, I've highlighted kind of the realities. And just one point on the no trespass order, this is just simply another misdemeanor offense. Right. And, whether it's charged, oftentimes these are charged, but when you're getting citations every 7 to 10 days from the police on these misdemeanors, and the court is simply spinning you back out on the street, there's no deterrent effect. So back to Senator Vahowski's point about what does it mean to be on conditions of release? What does it mean to have pretrial supervision and accountability sooner to deter a crime, as opposed to maybe a long incarcerative sentence way out in the future? Right, I lean toward let's make the investment on the front side. And I will just say, because I'm here, we do see with first-time offenders that go through our restorative justice process a very low rate of recidivism, and that's seen in data sets from different parts of the country as well.
Okay. Any other questions for the chief? Senator Norris.
Yes, thank you. I just wanted to get back to this 14 days. We've covered a lot of area here. I assume that all of Chittenden County is now on Belcour.
Yes.
I don't know if you administratively, do the officers clear their own cases through Belcour? And if so, how many days do they have to do just that? And then it goes to the supervisor, and how many days do they have to do that when we're honing in on this 14-day process, Chief?
Yeah, so we have an internal policy where if you make an arrest and issue a citation, the officer has to have their paperwork within a week. That's wishful thinking. Most of the time, the incident will exist and the defendant's name will be linked, And oftentimes you can look through the artifact that is there. You'll see like a dispatcher note that a citation was issued. So that's one logistical piece that's not great about what's here. I guess something that I was thinking about, but you'll need a prosecutor to maybe confirm this or deny this, is it a prosecutor's tool to say, I just got this case from Essex, this one from South Burlington, this from Wilson, so I've got 3. I'm over the statutory threshold. It's within the allotted time frame, whatever that might be. I then, as a prosecutor, make the intentional decision to whip this case as a felony. So perhaps that's how it's applied.
But Chittenden County is a little different, where the prosecutor's office always had the ability to get into Valcourt to a certain extent. Whereas I know that in the county that I was in, they did not. So we have to make sure that all 14 counties still had access to Valcourt at the state's attorney's office, I assume.
That's completely foreign to me, what level of access and how it's different in the counties. It doesn't seem like an effective use of the tool. It seems like the prosecutor, as the chief law enforcement organization, should have access to those records.
Yeah. Thank you.
Any other questions for the chief? Chief, thanks so much for spending the morning with us.
I appreciate it so much. It was an honor. Thank you so much.
Y'all come again now.
Yes.
Our next witness is Mark Anderson, Sheriff from Windham County. We are Windham County centric today.
Crazy what I have.
Must be
I don't
Senator
know.
Hashim's efforts on the agenda. Sheriff, good to see you.
Likewise, Mr. Chair.
Yeah, hopefully you're well prepared for the storm.
We are, Senator.
May have to go over the mountain and help Bennington, because we're supposed to get 60 mile an hour winds.
I did not bring my aircraft with me, but I'll work on it.
Okay.
I don't know that you'd want to be flying an aircraft in winds like
Don't be getting into
that.
Well, you'd go quickly over the mountain. Anyhow, we're dealing with H534. Any thoughts you might have on that?
Yes, thank you, Senator. Committee, for the record, my name is Mark Anderson. I'm Sheriff of Windham County. I'm here in my capacity as President of the Vermont Sheriff's Association. My testimony will be brief, not in reference to the bill itself, but because sheriff's experience is probably on the lower side of these types of incidents. The bill you heard before, I think it was H564, the motor vehicle one, we're probably more involved in more rural areas that we cover. That said, broadly, we support more tools that are solving problems. I think that's a simple statement. And so, Senator Sears, to your question, what are we trying to get at? I think it's how do we solve the problems? And so we've heard from the Association of Chiefs of Police, from Chief Burke, from the state's attorneys, that these are issues going on in places, and logically it makes sense. I echo some of the concerns that this committee has identified. I echo the concerns about is the number of days versus, for aggregation, or the county, how those things work. I think that those are all valid things to look at. I'm not sure that I have the testimony to offer. Senator Norris, I can speak to the conversation about Valcor. Since the state of Vermont entered into a site license for the software, all state's attorneys' offices have been granted access to it. There's some logistical pieces that we're still working out, but long story short, they do now all have access to it. And there's just training components that are involved in getting them all on board. I think that's really my testimony. I'm happy to respond to questions. We've heard talk about restorative justice, which we certainly support. I think the biggest component for effective solutions is the immediacy of the solutions. And so I share with Chief Burke, when we can get people on the front end, it's likely more responsive than after 9 to 12 months in the criminal justice system on the early side. The only other comment I want to make with regards to backlog and decisions by prosecutors. Certainly, I'm not a prosecutor, but in my county, following the large backlog from COVID, we were notified by our state's attorney of certain crimes that they were temporarily not going to prosecute on the basis of more severe crimes. And we didn't take that as an offense. It was a logical resource management decision. We supported that decision. And so while setting this policy and saying, will state's attorneys or prosecutors potentially not charge these? I think that that can be sometimes a short-term blip where the long-term policy of a law would ultimately be able to be evaluated by prosecutors, by judges, and by law enforcement saying this is not an appropriate resource management.
Thank you. Any questions for Sheriff Anderson? Sheriff, thanks so much. We appreciate it. Have a good day.
Thank you, Mr. Chair, and good luck.
Thank you. I think we need it. Rebecca Turner is next, and our final witness today on this bill.
Good morning, everyone. For the record, Rebecca Turner from the Office of the Defender Generals. I'll take advantage of having heard a lot of the questions and discussions and jump right to what I think hasn't been shared with this committee yet, but was presented to the House Judiciary, and that's the data, the national data relating to trends on retail theft coming from FBI that Chair Lalonde presented at the beginning of this, and specifically FBI's data relating to Vermont, meaning that it's a downward trend. CRG, Crime Research Group, Robin Joy presented data from that organization on Vermont retail theft trends. I think it's 2018 or 2016. I can hear her voice in my head and I just don't remember. But to the current date. Again, that data confirmed the FBI trends. That in fact, whatever is being experienced and anecdotally shared, the data that we have available is that at the statewide level, retail theft numbers are going down or returning to pre-COVID levels. At the local level, as a counter to the witnesses you heard earlier from Burlington and Wyndham, the Rutland Herald reported data from the Rutland City Police Department that crime trends, those numbers are lower from 2022 to 2023. That's a Rutland Herald report from January 24th of this year. The Rutland City Police. Numbers were down for this year as compared to last in every category, including retail thefts. So again, the picture of what is being experienced on the ground versus nationally, I just want to give you that perspective in terms of the data. The other interesting data point shared by CRG at House Judiciary was what is the aggregate average sentences being imposed by judges across the state for misdemeanor retail theft and felony retail theft, to understand whether or not the proposal here, which is effectively increasing the penalty, right, linking 2 misdemeanors or more to a 10-year felony, right, whether or not that's a need, whether or not the sentences that we're seeing actually imposed in the felony misdemeanor retail thefts in Vermont, whether they're near that max, right, so that you can sense that the judges are feeling confined, right? That would be at least my conclusion takeaway. Again, CRG shared that the average sentence being imposed for a misdemeanor retail theft is 0.03 years, turns out to be 11 days. The current maximum of a misdemeanor retail theft is 6 months. The average sentence being imposed across the state is 11 days, about 11 days. For a felony retail theft, again, the current maximum is 10 years. As Eric did during the walkthrough, the proposal here is to link the 2 or more misdemeanors to that 10-year penalty, right? What are judges in Vermont actually imposing when they get a felony retail theft and conviction before them? Average is 7.6 months. Now, to me as a defender, what are the takeaways from these numbers? Right? There's no problem with the current statutory penalty scheme for retail theft. Judges aren't anywhere near the max. They're not even at the average, the middle. Now, why is that? Judges in our system are given incredible discretion at time of sentencing to account for all sorts of relevant information, mitigate and aggravating circumstances. We've talked about aggravating circumstances as including a prior criminal record, prior criminal history, recency of prior convictions of misdemeanor retail theft. All of that, of course, is relevant, and the prosecutor would bring that in to argue and make the case for whatever is the appropriate sentence. What's interesting here, and presuming the players are all doing their jobs, the prosecutors are bringing in relevant information, the defense attorneys are bringing relevant information to the judges are exercising their discretion based on the individual person before them. These sentences that are far from even average indicate that there's a lot of mitigating circumstances being involved. And so while the goal that I hear is to target this sort of more serious, organized, sophisticated crime syndicate, what we've also heard from other witnesses this morning too, certainly our perspective from the defense side, is that this is a multi-layered issue whenever you have retail theft. Poverty, mental illness, homelessness, substance abuse. And so what is captured by the sentences where you see the judges imposing such little dates indicates that that is confirming what we suspect, that the underlying problem here is not a sophisticated, a lot of criminal culpability in individuals coming before court, but something else. And so then the fear of, well, then by increasing penalties, what do we send a message to? Is it another tool in the prosecutor's toolbox? Well, it's already there. It's not being actually asked for or imposed. What is the collateral consequences of felonies, which is the effect of putting 2 misdemeanors or more on someone's record? We know that it has considerable impact on employment prospects, right? Pursuing higher education potentially in terms of discretionary considerations, or maybe express threshold requirements for certain colleges and universities to not have a felony on your record, financial aid eligibility. I mean, that's just that voting in other states, if that's an issue. Again, if we're trying to help a certain population already impoverished and dealing with so many layers of challenges to then have a felony on their record because they're trying to survive. Again, these are the consequences.
Mr. Chair.
Yes.
So the last time we took this up, a couple of years ago, it was the Defender General himself was in testifying. I have a very persistent memory that he had constitutional issues around aggregating offenses. And I can't remember, and I don't remember it in fine-grained detail enough to know whether this would pass muster that way, but he seemed to be saying, as I remember, that what we were talking about was we would be aggregating the totals on things that people had been adjudicated on in the near past. This one has them adjudicated on these multiple offenses at one time. And I don't know if that changes the constitutionality concerns.
No, and I'm familiar with the Defender General's concerns about that in the past. I think it doesn't eliminate them, to put that answer up front. I think that black letter criminal law, the crime is made up of the act and the mens rea, the inculpable intent happening at the same time. Whenever you stray from that, is it a separate offense based on 2 different acts and intentions happening at different times, you run into tension with constitutional right to a jury to make the determinations of critical facts. Is it the judge making these findings at time of sentencing, or is it jury? Right, so there's that issue and constitutional questions, and so these types of ways to try to get to it bring that into tension with the constitutional requirements. The other is 8th Amendment proportionality concerns, and I think that raises that here. You go from a 6-month misdemeanor to a 10-year for the same mens rea, the same actus, just a different time of 14 days. I'll share what I experienced going through this on the House side. There was no data that I recall presented to show why 14 days made sense here. Was 14 days an average number of repeat offenses here in Vermont or elsewhere? It wasn't that data presented. So to me, it invites it's arbitrary. And to me, when it's arbitrary, I worry about the sweep of other people who are caught up in these types of offenses, not the type that I'm hearing you're focused on, which is the organized, sophisticated criminal syndicate. I'm worried about the clients who we see in the Defender General's caseload. I think the only other thing I wanted to add to broaden perspective and context to this question, the Sentencing Commission in 2019, November, submitted a report to the legislature and to this committee and to the House Judiciary Committee. The Sentencing Commission was tasked at considering reclassification of sentences for all criminal offenses and to address concerns about disparities of sentences around the state and whether or not they needed updating. I am the vice chair of Sentencing Commission. I was part of the subcommittee that was created, that was chaired by Judge Treadwell, to look at reclassification proposals for various types of offenses. Property offenses was one category of offenses we looked at as a committee over, I think the report said 11 times we met. It was a lot of time we looked, and it's a committee made up of representatives of the State's Attorney's Office, the Attorney General's Office, CRG, ourselves, I think, Judiciary. The committee came up with a recommendation submitted to the legislature in 2019, and the recommendation as to property offenses, there was notable some exceptions not relating to retail theft, was to reclassify based on the amount stolen. So this discussion about mere numbers and misdemeanors versus do we focus on amounts, I just want to share that the Sentencing Commission majority in the final vote supported reviewing and revisiting it and imposing max sentences based on amounts. They also suggested changing the current penalty of the felony retail theft, which is more than $900. They proposed changing that to a threshold of $100,000 to match the 10 years. Now, that wasn't an arbitrary conclusion.
100,000.
It wasn't an arbitrary conclusion. It was following, again, CRG provided considerable historical data on what were the sentences imposed. Again, similar to what we heard from Robin Joy in terms of the retail theft. Felony sentences imposed are 7.8 months on average, right? And so what we got into the granular level was where and how much amount was involved to the extent we could tell.
I'm having a hard time imagining anybody stealing $100,000
A
retail.
couple cars,
What's that?
but just a couple cars.
Well, then you're into a different statute.
I guess if you stole them from the dealership.
But I just want to,
Within a 14-day period,
In the same county.
same county.
what's striking is just to share that perspective coming from Sentencing Commission, which had an extraordinarily diverse membership from government, not community members. And that was the majority recommendation. So not just the opposite of what this is proposing, but a significant opposite. And so again, that is on the books there. I found it, I dug it up out of the legislature's website on reports filed. But that's all I have. I can go into more detail or many of these. Okay. Thank you. And Chair, Senator Sears, I wanted to say that I know you heard from people this morning on 563 retail theft, and you had asked and was interested in hearing from defenders from the field, and I didn't ignore that. I tried to get some public defenders in from Rutland, and their caseload is so busy that they couldn't make it, and I didn't have much notice. But if there is still interest, we are interested in coming and willing to come, and if I can get as much notice on the
I think at this point, on that particular bill, we have a number of questions, and it might be better to wait until we finish redrafting it. Michelle is out today, and so I don't know what the redraft will look like, but I have a sense that the committee is not comfortable with the way the current bill is drafted. Excuse me, the House passed bill.
That's great. So we'll stand by, but I just wanted to make sure, we had people who were interested.
And in this bill, as I stated earlier, I'd like to see at least a consideration of first, second, third, maybe even fourth and subsequent events rather than trying to aggregate to get to a felony level, which I have a hard time with, but also if there's a real problem, which your statistics indicate there's not yet in Vermont, although I think we're seeing it, organized retail theft, and there's two or more persons involved in it, then maybe we should consider that type of statute, similar to either, I don't know, Florida, California.
You know, the other point I didn't make is that there's also the judge's ability to stack sentences. Okay, so if there are multiple counts of retail theft, a judge has the current authority to stack 2 misdemeanor, max possible 6 months, or a retail felony, stack them consecutively so that they don't run concurrent. So that's another way to capture the concerns here. The other is that what I'm hearing you say, Senator Sears, in terms of a subsequent offense and suggesting an alternative penalty scheme based on a subsequent offense. Sentencing Commission, when we were revisiting or considering this proposal on reclassification of sentences in 2019, we did consider and we didn't make a recommendation to do that in terms of subsequent creating and building a penalty scheme based on second and subsequent. So for what it's worth, that it was landed on to rest on proper lines. Okay, thank you.
Yep.
Rebecca, I didn't quite, did you say did or didn't? I did the same, I apologize.
There was-
I didn't quite hear that. They did or didn't recommend subsequent offenses as a different alternative way.
Right, the committee, when we recognized what should be the classification, did not believe that didn't make any recommendation on the subsequent, second or subsequent. And it wasn't that we didn't consider it, it was considered, we just made no recommendation.
Okay, thanks. Sorry, I didn't hear it.
Well, it was just a starting point for the committee discussion.
So once we go
Well, I'm
offline.
looking at Illinois, and in Illinois,
Might want to not say that while we're still
a violation of organized retail crime may be investigated, indicted, and prosecuted pursuant to a statewide grand jury act, whatever that means. But a violation of 1 or 3 of the subsection is a class 3 felony. So what
I have the organized retail theft approach drafted, Senator.
Okay.
So-
Yeah, so if you come back next week with
Yeah.
organized retail theft, taking the miscellaneous, agreeing that we would take up the work crew in miscellaneous directions and focus on retail theft in the House passed bill. Retail, the organized retail crime. And then, I mean, I just did that as a starting point. We can discuss how we want to deal with it, but I think there's a lot less confusion to have it. Maybe the second, third, fourth subsequent events that.
Still is a little complex.
Yeah, simple bill. There is a problem.
There is a problem, but
But I don't know that this bill actually gets at what the problem is.
no,
I actually think S 195 is gonna be a better bill to get at the problem.
I do too.
the only answer, work crew.
As one of the sponsors on a constitutional amendment that would eliminate hard labor as a punishment for a crime, I feel like it's in opposition to my stance to support
Well,
work crew.
what's your definition of hard labor? I mean, one of the things we used to do at 204 Depot was we had a lot of kids who had community service as part of their DCF sentence or whatever you want to call it. So we had an arrangement with our local chamber of commerce, and they would do all kinds of stuff from mailing I don't know if mailing out notices to the chamber was kind of hard labor. I'm not sure that really fits in that.
It's labor.
It is
It is
labor.
labor, but I don't know if it's hard.
I don't know if it is either. But,
But they, and I tell you, it really did help, and the chamber was very
yeah.
supportive of our program, which is nice to have the Chamber of Commerce supporting you rather than all the liberal groups.
But our restorative justice system relies on community service too, as a means of helping repair the harm done to the community. So I think when it's commensurate and it actually is repairing harm, it makes sense. When it's just like, hey, you, go pick up trash on the side of the highway and hope you don't get hit by a speeding car, that feels a little different.
Cool hand loop.
Yeah.
We're back here.
I also think it's better than incarceration. I mean, it's certain designated jobs.
You're outside and.
So we're gonna have a debate about work through, but we'll have to use a different bill. I don't think it has anything to do with retail theft
Agreed.
necessarily,
Or shouldn't.
or should it? Everybody do